I'm a living man, capital E, lowercase RIC, of the capital M, lowercase ARTIN family.
Could you spell that one more time for us? Hey there, boys and girls. Wrangler here, and yes, we are back. And I was sick for a few days, but thank you all again that checked on me, and I really, really appreciate it. I'd like to thank all of our subscribers and our channel members. Without you all, we wouldn't be able to do what we do. And in this one, you have seen this guy before. He's a moron. He's one of these guys that believes that the SovCit bullshit is actually real, doesn't understand that it doesn't fly. Anyway, he's going to try his bullshit on a judge, and she ain't going to have it, but you will enjoy it, I promise. Enjoy, folks.
One of the people, sovereign, not a legal fiction corporate entity defendant with a name similar to mine, and here by special appearance to threaten, appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you?
No.
Listen, you poor dumb little crack baby. Are you the defendant?
Or is it just standby?
I made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Okay, that's it. Well, that's I was going to make the motion to dismiss him if he's if you're trying to appoint him for me, which.
All right, you're trying to half-ass make a motion to dismiss. On what grounds?
As I already said before, I want to be taking no attorneys. I'm one of the people. I'm not a defendant who's, yeah. So as I said before.
But yet you're in court as a defendant. How is it you are not the defendant?
So I'm not going to be accepting any attorneys who's going to fraudulently assume I'm a defendant, and which would then fraudulently give the presumption I'm under the jurisdiction of the court.
You're a bitch.
Well, you showed up at a date they told you to be there. You showed up at a time they told you to be there. And you showed up to the courtroom they told you to be there. So how are you not the defendant again? And how do they not have jurisdiction over you?
All right, yeah. Like I said before, I'm a living man. So as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without her consent. I don't consent.
She doesn't need your consent. The criminal court does have jurisdiction over you. You're there, aren't you?
And it's also under, there's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions, though, for the prosecutor.
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
In other words, do as you're told, bitch.
Well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not. There's no standing, shouldn't move forward. But
your motion is denied as to jurisdiction and standing. Now, do you have any additional motions?
I object to that because you didn't already. You're going to.
First of all, a demand is not a proper format before a court.
Mentioned before, demands when someone has the right. That's what the terminology demand is made, and that's the only reason why I make it.
Mr. Martin, do you have a copy of Black's Law Dictionary, 2nd edition?
Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's why I objected 5 minutes being any time limit also.
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Boom. Roasted.
Well, the police, I want to question the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination, move to dismiss the case based on that because he made me give, my ID. but my memory was it's a little, I don't really remember exactly what was said. That's why I kind of need to question them
You should never drink the bong water.
now. And also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying.
Yeah, that's called discovery, dumbass.
Like I said, it violates my self-incrimination right.
No, self-incrimination has nothing to do with the Sixth Amendment, dumbass. That would be the Fifth Amendment.
Oh, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you like 2 days ago. So the court will be getting it, if they didn't get it already, begin this week.
As to your motion to recuse, that is denied.
Based on what reasons?
Based on the fact that just because you verbally pulled out of your ass, Judge, I'm suing you, that is in no way official. So until there is a piece of paper in her hand that after she has been properly served, you haven't filed anything.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crime carrying passengers probably for profit. You're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle.
Do you possess a license in which to operate that motorcycle on public roadways? Is that motorcycle registered with the state that you live in? Does it have current registration? Do you have, as required by law in any state in this country, mandatory minimum liability insurance on that motorcycle?
USC section 31 subsection 6 and statute definition of motor vehicle applies here. It overrides the state statute.
A dictionary, regardless of the manufacturer, edition, or date of publishing, in no way will ever override a law that is a law. Sorry, swing and a miss.
Under Article 6 of the U.S. Constitution, laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong.
Except for what you've been criminally charged with or accused of. That's why you're in court, to prove your guilt or non-guilt status.
I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance.
Could you say that one more time?
Traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper.
Now that you and I will agree on, but the legislature in your state has deemed it necessary for a license, registration, and to possess mandatory minimum liability insurance. You just actually sunk your own boat, dumbass.
As they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stop and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also federal crime, which I'm going to be contacting the FBI about. I already tried once. I got to call him back.
All right. Well, if he's going to go to the FBI, Judge, you better dismiss this case with prejudice right now.
Because it's putting it's a blanket on a lot of people that don't know no better in the system. Something else. Now, when this proceeding started, I noticed on the screen for everyone else, all the people have a right to record in any public court. This is all public. The U.S. Supreme Court already said this. People have the First Amendment right to record.
Wrong, 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 wrong. Wrong, 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 wrong.
No, the Supreme Court ruled with the case law commonly referred to as the public forum doctrine that those that run the public building that you are going into have a right to deem what you're allowed to do in there and what you're not. Swing and a miss, strike two.
Oh, you were finished. Oh, well, allow me to retort.
Madam Prosecutor, after you, ma'am.
He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other two. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next.
Martin, take notice. This is how you address the court.
Is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple of things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh, yes. Penhallow versus Doan's Administrators. That's a case from 1795.
Eric Martin, 1795. You're kind of reaching, aren't you?
And the specific quote in the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washtenaw. So just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. But I might want to point out the manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal or even a federal lawsuit does not insulate you from the contempt powers of that very same court should you choose to continue escalating that type of behavior. That's just the more you know for me.
As he's sitting up there trying to shuffle through his Black's Law Dictionary, 2nd edition, that right there is how you properly own a SovCit bitch in court. Madam Prosecutor, great job.
Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and titles something as a criminal complaint, it doesn't make either of those things true.
So in other words, dumbass Eric Martin here has no idea what he's doing, and he should probably accept the court-appointed defense attorney.
So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. the prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to. So nothing more from that. The court's rejection of an improper filing really isn't my business. So no response from opposing counsel would apply today. The last two things that were filed before the court are two demands. The court has already mentioned demands. I'm so sorry. It's a lot of talking happening here. I gotta refresh. Two demands.
Yeah, I understand, ma'am. It's a lot of bullshit that you have to respond to.
One demand for default judgment and another demand for summary judgment. Both of these I would have the same reaction to. The demand for summary judgment, summary disposition concerns parties to a civil action, and defendant is referring to civil procedure, not criminal procedure. There is no summary anything of that notion in criminal matters. Now, he made some references to Article 3 of the U.S. Constitution. So this court is not controlled by Article 3 of the U.S. Constitution. But I think he knows that because he's citing Michigan court rules to sustain his argument for pretty much everything else. So that doesn't change here. Summary judgment is not a thing. Did not respond to the request to return his motorcycle for that first filing that I mentioned, that he should have a default judgment and he should automatically get what he's demanding because he didn't respond to it. Well, I'm responding right now, but that's not how it works either. Again, this is kind of a civil issue. There are cases where there are default judgments filed, but those are civil actions. We have traffic tickets that defendants fail to appear and get a default judgment. But if that were the case, I would have a default judgment of conviction for every criminal case where defendants fail to appear. People are on bench warrant status for 6 to 20 years at a time. I don't get automatic default convictions. So again, that's really not what's happening here. So those are the 5 things that I'm aware of. Now, finally, if it were true that, as Mr. Martin stated, that federal law trumps all state law.
Well, I guess that this is where that pesky 10th and 14th amendments are going to come into play.
And that all state law and state courts are unconstitutional. The state court system would not exist. And the U.S. Supreme Court would not hear cases resulting from the need to interpret state law. Mr. Martin has yet to hear, as all of us do, of state constitutions and the power of the state courts that come from those being abolished. So his reference was correct, that there are people in this system who don't know any better and don't know what they're doing.
He's one of them, isn't he, ma'am?
I don't think present company is excluded from that. So on that note, Mr. Martin, if you want to continue without an attorney, you can, but I wouldn't recommend it.
Notes on everything, hard to follow along with everything else. I think it's best to, same with me too. I say one thing, allow her to respond back. She says one thing, then allow me to respond at one instead of, you know what I mean? Like me saying the whole bunch.
Well, yes, that's considered proper etiquette, not to mention, polite. But here's the thing. She knows what she's doing. She's educated, which means she actually went to college, law school, took the bar exam, passed the bar exam, and has experience as a trial lawyer. You watched some videos on YouTube. You bought a SovCit bullshit package from whoever your damn guru is, and you think that magically means you're going to defeat this young lady in court. Good luck.
And then sure saying a whole bunch because it's hard to follow along for both of us, I think, harder.
I don't think she's having any problem following along.
At least me, and for both, I think it's common sense, but all right, well, so I'm gonna respond now to the things I could follow along with, and I took some notes, but I'm gonna need her to say again what I missed, and then I can respond one by one. Okay.
That's not how this is gonna work, sir.
That's
I
not
think
how.
To understand here, you
I have the right to that. What are you talking
you're
about?
not controlling this courtroom, sir. That's not how this works.
I'm speaking about what I have a right to do. I have a right to respond back.
You're
All
gonna
right.
get 5 minutes, and I'm gonna be done. So that is your opportunity. And after that, I'm gonna make my rulings. You got
Well-
5 minutes. I'm actually setting a timer. You're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You got 5 minutes now. Please move forward.
Criminal I want to object to that too, though, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant.
What you said about that MCR, refusal to act on my criminal complaints that I filed because of MCR 6.101. And now, first of all, it violated my due process right, obviously, because they didn't mention a subsection of that rule. There's many subsections.
Yes, but they in no way, A, infer what you think they do, and B, don't apply.
Okay. So I'm still left in the dark on what specific subsection it is.
And that's why they offered you a public defender, you fucking crackhead, because you don't know the law.
And all those apply to specific fact situations. So that was the first due process violation right there, just mentioning that too vaguely general. Number two, but assuming it was based on not paying a fee or whatever, I think like she mentioned, or getting a prosecutor's approval. Okay, if it is for that reason, those reasons are unconstitutional.
And unless you have something very specific that applies to this court at this time, any argument you make on the unconstitutionality of this hearing is for an appeals court, you jackass.
And therefore it's invalid, that court rule. That's why I'm going to file a class action actually on the court rule. And I'm going to get that court rule and get up out of there because it's not legit. Why it's not legit? Because,
Let me guess, because you said so?
but I mentioned in my paper, in some future paperwork anyways, I know that if I didn't do it on this one.
Wait, you're trying to cite shit that you hadn't even submitted yet? Dude, get off the pipe.
In the very first one, because I didn't know, what the hell subsection it was talking about. They didn't mention it, but I know I mentioned it in some later ones sent to you guys. But anyway, so yeah, so it violates that right, and also the U.S. Supreme Court case Murdoch versus Pennsylvania, and I got the volume number, page, and all that. I think I cited you guys before in the paperwork. It says that you cannot deny someone's constitutional rights by trying to make them pay money for something.
Okay, so which constitutional amendment states that you can ride an unregistered motorcycle without insurance, without a license on public roads?
A right's a right. Bringing something to the court's a right to be heard is a right. I don't have to pay money for that, criminal or civil case. Okay, so it violates due process. So all that's legitimate. They're illegitimate, that is, their arguments are using for that. It's supposed to be something that's clear right in there.
That poor public defender looks like he wants to start a shotgun right now. And the prosecutor is just laughing her ass off. And I can't blame her because this is beyond pitiful at this point.
I didn't have enough time to go over the Penhollow case, but if I remember it, I was just in the law school law library recently trying to verify that quote.
And what relevance does that have today, sir?
Because a lot of these quotes that I got, that I'm citing in the court, some of them I have read and some of them I haven't. This Penhollow case.
Wait, so you're actually trying to, as part of your official argument, you're claiming that you're using quotes that you haven't even read the cases for? Seriously? Dude, are you related to someone named Chris Ryder?
I'm not sure on that. I admit that. I have to double check myself because a lot of these I get online, YouTube, and
wait, did he literally just say that he gets his ideas from YouTube? Let's listen to that again.
I get online, YouTube, and a lot of them have been shown up to be legit because I go to law library and I double check on them, the quotes. In the Penhollow case, if I vaguely remember, I think I did have a problem myself finding that quote, saying that exactly like that.
So you're saying that the bullshit you learned on YouTube, you couldn't find in a law library?
But that's not saying it doesn't stand for that proposition. I'm sure it still does. I just got to go back to the law library and read it again. If I did read it, I kind of don't remember because, I got a lot of stuff I'm doing, but
oh yeah, you're doing lots of stuff. And the stuff that you are doing that goes in the glass pipe, I would recommend you stop doing. It's not helping you.
Yeah, so bottom line, I gotta check up on that case. So it'd be premature to rule on it yet.
It would be premature for the judge to rule on something that her, the prosecutor, your court-appointed defense attorney, have already read because you haven't read it.
But I know U.S. Supreme Court cases still say it because it's all based off the Declaration of Independence, and so there should be no doubt on that. And U.S. Supreme Court cases exist that say that Declaration of Independence is part of federal law, United States Supreme Court law.
And the Declaration of Independence has exactly what to do with you not having insurance or a driver's license or a properly registered vehicle. Exactly. And if you can show me anywhere in the Declaration of Independence it says motorcycle, I'll give you my car.
It's the basis of the Constitution, so it's legit. That as to the proposition that governments have no power over a human without our consent. All right, now as to the summary judgment that she mentioned, Chapter 2 doesn't apply. That is not true because...
Oh my God, look at the defense attorney, man. He just wants to go play in traffic. I feel so bad for that man.
Since there's not a summary judgment in Chapter 6 of the criminal rules, then I forget exactly where it mentions that, but it's in the court rules or another law. But I remember reading it. So that just totally, it's not true. So the summary judgment, it does apply.
No, summary judgment does not apply in criminal cases. That would actually be a violation of your Sixth Amendment, you freaking moron.
In criminal cases, because there's nothing in Chapter 6.
Because it doesn't exist?
And regardless of that, in regards to the court rules, you got to remember, court rules follow, the Constitution is the top dog anyway. That's the top law anyways. And due process right to have some considered and ruled on and denied in my case. I mean, the case dismissed because based on my constitutional rights.
What constitutional right? Show me one place in the Constitution that says you can ride a motorcycle on public roadways without a driver's license, without insurance, and without proper registration. Show me where that is said anywhere in the Constitution.
That's just something I have a right to anyways under the Constitution, regardless of court rules. Because the court rules come after the Constitution anyways, and they don't always follow the Constitution.
All right, 5 minutes are up.
Thank you, Jesus.
So I got more to say, but so I'll...
The word dilligant. That's spelled D-I-L-L-I-G-A-N. Dilligant. And it means, do I look like I give a fuck?
I'm going to move for an extension of time on that. Based on my First Amendment right. I got some more to say.
I'm sorry, Mr. You wanted to move for an extension, so I just want to are we selecting a jury next week or no? It sounds like he wants to talk more.
He does want to talk more, but I'm not the fact that the court doesn't do that. He also filed lawsuits against individuals. Those were also rejected by this court as improper. And there's nothing to really address about that. It's already been decided. His motion to dismiss is denied. Despite his understanding of the law, and I'm not certain which law school he went to.
That would be YouTube Law School, Your Honor.
Summary disposition does not apply to criminal cases and is denied. And same is true for default in criminal cases. That is also denied. Jurisdiction is with this court, as I've ruled before, and I will not be addressing this issue again. The motion to dismiss is denied. There was one point that he did make with respect to due process that is going to compel where we go with this. He does not get to question officers except for in a trial. However, he is entitled to discovery in this case. And he mentioned that he did not receive a copy of the video, if there is a video, or if there's body cam, he's making a demand for that. And he is entitled to have a copy of any body cam that exists in this case and a copy of any police reports that exist in this case. So those items need to be turned over to the defendant so that he can properly prepare for any trial. And trial right now is scheduled for 1 week, so I don't think it would give him a proper opportunity to prepare. I will remove this from the trial docket for this upcoming week to and there is one place in which criminal cases does have a demand, and that is a demand for discovery.
It's been reaffirmed today that I'll figure it out. We'll get it done.
What do you have an email, or are you just gonna, Mr. Martin, are you requesting to have the documentation sent to you via mail or email? How do you plan to receive it, sir?
First I want to refer to me as Mr. I understand that's another one of the term Mr.
Oh, for fuck's sake.
Is another one of the what's the words I'm looking for? I forget what it's called here.
All right, you can where you would like to figure it out to give him that documentation.
Legalese term, that's the word I look for.
No, you need to be looking for a 12-step program and a sponsor.
The Mr. is a legalese term that's fraudulently assuming I'm a defendant and all that, but
no, Mr. is a term that's assuming that you're a male. Now, while I have serious doubts as to whether you actually possess male genitalia or not, it's not fraudulent. Sorry, bud.
Anyway, so
Yes, Your Honor, while you look for that date, I will just state on the record, if Mr. Martin, Eric Martin, living man, the individual sitting here before me today speaking, if you would like discovery, I would highly suggest that you give the court an email address or some method by which we can deliver that discovery to you, because I'm not trying to keep it from you, but if you don't help me to help you, I can't get it to you either.
Oh, I don't think I'm a lot dumber than you thought that I thought I was once.
I'm gonna give them my address, and I'd rather do it through my physical address here at the home. I just wanted to object to the term first. That's all. Before I forgot, or you guys keep going on. Don't let me do it. But
great, because the whole time they were looking for your permission to do the job to which they know what they're doing.
Same address I've been sending my demands to and all that, my paperwork. Taylor City, Michigan.
Whoa. I'm talking over because this is live. You don't want everybody in the world to know your address, sir.
And boys and girls, that's where that ends. I got to tell you, I know this was a long video, but we hadn't had anything out all week. But this guy, we've come across some dumb SovCit idiots and frauditors in the 18 months that we've been doing this. But this is, wow, he is special. Anyway, guys, it's Wrangler. I'm out of here. I love y'all. Have a good one.